Hello everyone, a very good morning to all of you. Welcome to the Officer Adda 24/7, the special session of your BRBL subject in the English medium language. So you know that we are doing the questions of module B, that is very important. Okay, and this is your resolution batch. As you can easily see that this batch is already started from 10th of January. The rest of all subject will be start from the February. So if you want to enroll in this batch, you simply have to apply the coupon code, that is Y391, for the maximum discount, because in this batch you will get the live classes of all the 4 compulsory subjects, plus you will get the recorded session. Suppose if you are not comfortable or if you are not able to attend the live classes, you can see the recorded session, plus doubt session will be available, etc. So if you want to enroll in this batch, apply this coupon code. You will get up to 80% of discount. Okay, now let's do the question. Number one question. Which of the following section in the NI Act deal with the Bill of Exchange? It is section 5, 6, 4, 13 or 12. So what is Bill of Exchange? We know that A person is there, B person is there. A want to give something. A suppose have given the goods to the B person. In that case, B have to give money, but right now B is not giving money. In that case, what will A will do? A will just make a bill of exchange. Okay, this is a particular document, bill of exchange, in which he will write that B will give money after 1 month to the C person. Okay, and A will sign here. A will sign here. After that, B will sign here. Because when A sign this document, he will be send it to the B person. And B person have to accept it within 48 hours. That is a rule. Within 48 hours. Okay. And then after, give it to the C person. So in the bill of exchange, you can see there are 3 parties. The first is maker. Who is maker? A is maker. You can also call maker as a drawer. Done. After that, C person, that is called pay. Okay. And this B person, that is called Troy. So this is, you can say in the bill of exchange, if any question will come now. So the bill of exchange, the total party of the bill of exchange is basically, that is 3. Okay. And the definition is defined in A part, this one. So this is the right answer. So section 5 is bill of exchange. Section 6 is check. Section 4 is promissory note. 13 is negotiable instrument. 8 is holder. So this is the important definition of your part. That is important. Okay, this is the important section, we can say that we have to learn in the NI Act. That is important. Okay, class. So this is the important one. Any doubt in this question? Okay, so this is important from the exactly, just remember these things so that you can able to understand the particular answer. Okay, now let's move toward this. Which of the following are not the negotiable instrument as defined by the state law? Banker note, promissory note, bill of exchange, check, all the instrument are negotiable instrument act. Now just please remember the this one and tell me the right answer. Hanji class, which of the following is not negotiable instrument as defined by the state? Banker's note, promissory note, bill of exchange, check. So in the previous question we have already discussed this and this, okay, but this thing we have not discussed, so it is but obvious that the A is not given in your part. Okay, A is not given in the particular NI Act. Okay, so this is the right answer. Next, which of the following is true about the promissory note? Okay, the definition of promissory note is given in section 8 of NI Act. Second, containing an unconditional undertaking. Third, pay a certain sum of money only to the specific person and bearer. The sailor is bound to accept the promissory note, a document written and signed by the payer and maker. What is the right answer? Tell me, class. What is the right answer? Which of the following is true about the NI? See, first definition is 100% wrong. Why? Because this definition is defined in section 4. So first is wrong, first is wrong, first is wrong. So the answer cannot be D, it cannot be A. Okay, now second, containing the unconditional, second is right, second is right. Now third, to pay certain sum of money only to the specific person or the bearer. That is also right. Third is also right. Third is also right. Now fourth, fifth. The sailor is bound to accept the promissory note and the document is written and signed by the maker and payer. So what is the right answer for this question? So for the third one, okay, the sailor is bound to accept. That is not necessary. But the document is written and signed by the maker. That is right. So fifth is right. So that's why the answer will be B. Is that okay, class? The answer will be B. B is the right answer for this question. Okay, if I say you in the one word, the promissory note refer to the written promise to its holder by an entity or individual to pay the certain sum of money by a pre-decided date. Okay, and the definition is defined in section 4. The sailor isn't bound to accept the promissory note. So this is the important segment of this part. Okay, that's cool. Next question. Dishonor of NI, okay, negotiable instrument by non-payment is covered under which section of NI Act? 90, 91, 92, 93, 94. Tell me, class. What is the right answer? Dishonor of NI is covered under which particular instrument? This is given in section 92. You have to remember this, okay? Okay. The Negotiable Instrument Bill 2017 inserted a provision allowing a court trying an offence related to the check bouncing and direct the drawer to pay the interim compensation. That is very important. What is this? Interim compensation to the complainant. Now tell me, the interim compensation will not exceed dash of the check amount. It means whatever the amount that is written in the check, so the person have to pay dash percentage of the check amount. And interim compensation is C. The one is Final compensation. Final means that after the decision. And this is interim. Interim means temporary. That is temporary compensation. So what is the right term? What is the right answer, class? Tell me. So class, the right answer will be they have to pay within 20% of this one. So 20% is the right answer. Within 60 days, okay, within 60 days they have to pay. Okay, 60 days they have to pay plus extra 30 days will be also given to them. So this is the right answer. Fifth E is the right answer. Okay, now what is true about the bill of exchange? Bill of exchange required in its inception two party. Bill of exchange or draft is written order by the drawer to the drawee to pay the sum of money. Bill of exchange is used primarily in international trade, written order by one person to his bank to pay the bearer a specific sum of specific date. Definition of bill of exchange is mentioned in section 6 of the NI Act. What is the right answer? Raji class. What is the right answer for this question? What is true? First of all, the bill of exchange that is saying it have a two parties. The answer is absolutely wrong. First is wrong. First is wrong means this cannot be the right answer, this cannot be the right answer. So A and B cannot be the right answer. Okay. The bill of exchange or draft is a written order by the drawer to the drawee to pay the money to the pay. Okay. Written order, drawer to drawee to pay money to the pay. This is absolutely right. Second is right. Second is right. It means C. C is right. Second is right. Definition of bill of exchange is defined in 6. This is absolutely wrong. Fourth is wrong, class. Fourth is wrong. Fourth is wrong. Fourth is wrong. So the right answer is C, class. Right answer is C. So this is right and this is right. These two things are right one. Is that okay? So this is the right answer for this question. Done? Now, next. If the holder of bill of exchange allow the drawee more than dash hour exclusive of public holiday to consider whether he will accept the same, all previous parties not consenting to such alliance are thereby discharged from liability to such holder. 24, this, or what? This is A, this is B, this is C, this is D, this is E. What is the right answer? Seventh one. For the seventh one, the right answer is C. In the bill of exchange, always remember that drawee have to accept within 48 hours the bill of exchange. Okay, so this is the law which is in the bill of exchange. What is section 6? Check, bill of exchange, promissory note, dishonor by non-payment, dishonor by non-acceptance. Dishonor of non-acceptance is always for the bill of exchange, always remember. And non-payment, this is for promissory note, bill of exchange, and check. Hanji class. So what is section 6? That is check. Okay, now if a minor draw, endorse, deliver, negotiate the negotiable instrument, it's bind what? All the party except minor, all the party including minor, minor only, minor and only dropper, minor and only draw. What is the right answer? What is the right answer for this one? Hanji class. This is very good question. Minor means the person who is below 18. Below 18 is always minor. Endorse, deliver, negotiate, negotiable instrument. It bind whether the minor will be liable or not. The minor is absolutely not liable. So for the ninth one, the right answer is all the minor, all the parties except the minor. So for the ninth one, A will be the right answer for this question. Okay, A will be the right answer. Do not forget to like and subscribe the channel of Officer Adda. Okay, now what is false about dishonor of check? False. And we know that the dishonor of check is given in section 138 of the Act. Section 138 defined dishonor of check for insufficiency, that is of fund in the account. Such check has been presented okay. Such check has been presented to the bank within the period of 12 months from the date on which it is drawn and within the period of its validity, whichever is earlier. Imprisonment of such offence which may be extended up to the 5 year and 138 apply unless the drawer of such check fails to make the payment of the said amount of money to the payee or as the case may be to the holder in the due course within the 15 days of the receipt of this. What is the right answer? False. You have to just tell me the false one, okay? Imprisonment is not this one. Third is false. Third is false. It means this can be the answer. This can be the answer. 138 dishonor of check. This is right. This is right. So this cannot be the answer. Okay. The check has been presented to the bank within the 12 month. Within the 12 month. This is absolutely false. So the right answer is B is the correct answer for this question. Okay. D is the right answer.
Hello everyone, a very good afternoon to all of you. Welcome to the Officer Adda channel of Adda 24/7. So today is Monday, 22nd of January. First of all, Jai Shri Ram to all of you. So guys, we are doing the module wise question, okay? And we have done module A. We have done module B, and right now on the occasion of Ram, the event which is going to be which is already started today, okay? So today we are going to start module C, question and answer. And first of all, please remember, module A contained 2 acts, module B contained 4 acts, but module C contained 10 acts. So module C is very, very much important from the examination point of view. So if you really want to crack this exam now, so 40% I can say cover question from module C. So one by one we will do the questions, okay? So now let's start with the module C. It's 10 content. Before starting this session, I would like to say you that this is your resolution batch of 2024 June. If you want to enroll in this batch, you can please enroll by applying the coupon code Y391. Now, let's start with the session, module C. Today we are going to start Lok Adalat, the questions of Lok Adalat. So Lok Adalat is basically, if I say you, we know that we have a court. But you know class, the court take so much time. There is so much procedure that we have to follow in this, right? There is so much technicalities in the Lok Adalat, as we know that. Okay, so that's why we have a certain ADR. What is ADR? ADR is basically, okay, this is the alternative dispute resolution. What is ADR? It's an alternative dispute resolution. Okay. So there is a Lok Adalat, Ombudsman, Consumer Forum, arbitration, mediation, negotiation, conciliation. So there are so many ADR system in our India. Okay. So the basic purpose of ADR is to basically to give justice in the speedy way. Because in the court, adjournment to adjournment is there, but in ADR system at least there is a simple process in which the court, these will also called the quasi court. This is also called the quasi court, whose basic aim is to settlement of dispute, okay, and the next one is compromise the dispute. Settlement and compromise is the basic aim of this particular thing. So now let's start with the session. Number 1 question on the screen. What is the correct method of ADR? Legislation, arbitration, negotiation, or negotiation, legislation, mediation, arbitration, negotiation, conciliation, mediation, and legislation and mediation. What is the right answer for this question? Tell me, guys. What is the right answer? What is the right answer for this question? Yes, class, tell me. What is the right answer? Always remember, legislation cannot be the right answer because legislation is basically the parliament. Legislation is basically parliament. So what is the correct method of ADR? This is very simple question. A very simple question, class. So if I say you, the right answer will be arbitration, negotiation, conciliation, mediation. This is the correct method of ADR. So ADR is basically whose main purpose is to solve the disputes and compromise the matter. Okay, now next. Lok Adalat is a mechanism for avoiding the litigation, dispensing speedy justice, reducing the speedy justice, and correcting the administration. What is the right answer? Hanji class, what is the right answer for this question? The right answer will be avoiding the litigation, dispensing speedy justice, reducing the speedy justice, and correcting the administration. So the right answer is dispensing the speedy justice is the right answer. This is the basic aim of Lok Adalat. Okay, B is the right answer. Lok Adalat is a mechanism for same question. B is the right answer. Now, which of the following is the correct with reference to the Lok Adalat? It has pre-litigative jurisdiction, consists of a sitting or retired judicial officer, criminal jurisdiction, or none of the above. What is the right answer? What is the right answer for this question? So class, it is a pre-litigative jurisdiction, consists of the sitting and retired judge, criminal jurisdiction, and none of the above. Correct. So if I say you the correct one, so it consists of a sitting and retired judicial officer. Okay, sitting and retired judicial officer, and the other person can also come in this picture. Okay, so it is a pre-litigative as well as the and post-litigative also. Okay, post-litigative also. So that's why fourth one, B, is the right answer. Okay, B will be the right answer for this question. Where was the first Lok Adalat organized? Andhra Pradesh, Maharashtra, Gujarat or Rajasthan? Tell me, class. The first Lok Adalat. In which state? It is Andhra Pradesh, Maharashtra, Gujarat and Rajasthan. What is the right answer? The first Lok Adalat organized in Gujarat. This is the right answer. Okay. With the reference to Lok Adalat, which of the following statement is correct, class? Lok Adalat have jurisdiction to settle the matter at a pre-litigation stage, not those pending before any court. Second, Lok Adalat can deal with the matter which are civil, not criminal in nature. Every Lok Adalat consists of either serving or retired judicial officer only, not any other person. What will be the right answer for this question? Very important question. So the right answer is Lok Adalat have jurisdiction to settle the pre-litigation, means before coming in the court, we can just give the matter to the Lok Adalat. This is right. And we can also give the matter in which the case is pending before the court. So this is not the right answer. Lok Adalat can deal with the matter which is civil, also with the criminal nature. So this is wrong. This statement is right. Every Lok Adalat consists serving trial judge only and not other person. This is wrong. So guys, all this statement is wrong. So that's why D is the right answer. D is the right answer because in the Lok Adalat, it consists serving an retired judge plus other person also. This is the right answer. Lok Adalat has been created under which act? Arbitration and Conciliation Act, Supreme Court of India, Legal Service Authority Act, or 73rd Amendment of the Constitution. Which of the following is the right answer, class? Tell me. Under which act this has been made? So the right answer is Legal Service Authority Act 1987. This is the right answer. Which of the following is not referred to arbitration? Civil matter, matrimonial, banking matter, and property matter. Tell me, class. Which of the following matter is not referred to the arbitration? It is civil matter, matrimonial matter, banking matter, or property matter. Which of the following is the right answer? So, matrimonial matter not covered under the Arbitration Act. Okay. What does ADR actually stand for? Alternative Disparate Resolution, Alternative Dispute Resolution, Alternative Dispute Resolution, and Additional Dispute Resolution. What is the exact answer? So if you will see, that is an Alternative Dispute Resolution. C is the right answer. Now, ADR play a significant role in reducing the burden upon police station, upon political party, upon underworld, or upon the court. So ADR is the helper of what? Tell me, class. ADR is the helper of ADR is basically the helper of, that is a court. This is the right answer.
Hello everyone. A very good morning to all of you. Welcome to the ऑफिसर अड्डा चैनल ऑफ अड्डा 24/7. आप सबका बहुत बहुत स्वागत है. जो भी so this is your officer Adda channel. Welcome to this channel. So we are doing module C questions. Okay, so in today's session also we have to do the module C question, and the today's act name is your basically that is Consumer Protection Act. Okay, first of all I would like to ask you that what do you know about this act, because this is very important from the examination point of view. Hanji class, tell me. Hello. Yes, class. What exactly the Consumer Protection Act means? So if I say you that what is consumer? So we have to understand the consumer is a person, okay, who consume the goods and avail the services. That is called consumer. Okay, consumer means the person who consume the goods and avail the services. That is called consumer. So class, if any defect will come in the goods and services, so for that thing, this act is there in which they can go and the justice will be given to the consumer. So that's why we have just made this act, that is Consumer Protection Act 2019. But this act, initially the act year is 1986, but there are so many amendments happened. So in 2019, the act has been changed. So many provision has been included, okay, in the Consumer Protection Act. So many provision, okay. So let's do the question of these one. Number one question. As per Section 2, Clause 1B, the Consumer Protection Act, complainant means what? What do you mean by the term complainant? A consumer, any consumer association registered under the Company Act 1956, central government or any state government, or D, all of the above. Tell me, class, what is the right answer? Complainant. So complainant means the person who complained. So this is, this question is of your definition portion questions. What is the right answer? Tell me. Hanji class, what is the right answer? Complainant. Complainant. A consumer association registered under the Companies Act or the central government or the state government. According to the act. Okay. You have to give me answer according to the act. What is the right answer? This is very simple question. Okay. A very simple question. So the right answer will be all of the above is the right answer. So complainant can be consumer, can be central and state government also, because we know that central and state government also purchase the thing and the consumer association registered under the Company Act. So for the first one, D is the right answer. Is that okay? First one, D is the right answer. And do not forget to subscribe the channel of Officer Adda. Okay. Now, next question. As per Section 2, Clause 1, Clause C, the Consumption Act, complaint means that any allegation in writing made by complainant that a trader or service provider has charged for the goods or service a price in excess of the price, what it called, fixed by or under any law for the time being in force, displayed on the goods or any package containing such goods displayed on the price list exhibited by him or agreed between the party. What is the right answer? A, B, C, A, C, D, A, B, D, or A, B, C, D? What is the right answer for second one? That is very good question. Hanji class. What is Complaint. Okay, complaint word is given here. You have to tell me that which of the following is the right answer for this one. Complaint. Because in every act, definition term is very important. Now, I think in December 2023, 5 to 6 questions were come from the definition term. So definitions are nothing but in the slide that we used, this is called definition. So what it exactly means? So according to the given act, the right answer will be all of the following. Okay, the right answer will be A, B, C, D, all. So complaint includes all these things. So D will be the right answer. Okay, D will be the right answer here. Is that okay? Now the next one. In the case of death of a customer who can prefer complaint under section 2 clause 1 under the protection under this act. So who can complain? His legal heir or representative, state government, consumer association registered under the Company Act, or no one can prefer the complaint. What is the right answer? What is the right answer? In the case of death of a consumer who can prefer complaint, so who can prefer? The question is who can prefer class? Who can prefer? A legal heir or representative, state government, consumer association registered under the Company Act, or no one can prefer the complaint. What is the right answer? The right answer is his legal heir and the representative can this. So A is the right answer for this question. Is that okay? Next. Which of the following statement is false regarding the consumer rights? We know that there are 6 consumer rights. So you have to tell me which of the following is the false regarding the consumer right. The first, right to be informed about the quality, quantity, potency, purity, standard, and the price of goods, product or services as the case may be, so as to protect the consumer against unfair trade practices. Second, right to be heard and to be assured that consumer interest will receive due consideration at appropriate level. C. Right to seek redressal against unfair trade practices or restrictive trade practices or unscrupulous exploitation of the consumer. And D. No right to be protected against the marketing of goods, product or services which is hazardous to life and property. So which of the following is the right answer? Do not forget to like the session, subscribe the channel of Officer Adda. हाँ जी class. Tell me, class. Right to be informed, right to be heard, right to seek redressal. These are the consumer right. But right to be protected is a right. And in this statement, no is written. So that's why D is the right answer. D is the right answer for this question because the no word is written here. Okay, the no word is written here, and we know that right to be protected is also the consumer rights. So that's why D is the right answer. Next, district commission shall have jurisdiction to entertain complaints where the value of goods and services paid as consideration does not exceed rupees 25,000, 1 lakh rupees, 1 crore rupees, 50 lakh rupees. What is the right answer? Tell me, class. And see, I'm just writing the jurisdiction of all the 3 years: 1986, 2019, and in 2021 also the amended term. This is district commission, state commission, and this is national commission. Okay, so in 1986 the district commission was up to 20 lakh, 20 lakh to 1 cr, and national above 1 cr. 2019 it was up to 1 crore, 1 cr to 10 cr. This is above 10 cr. Okay, in 2021 up to 50 lakh. This is 50 lakh to 2 crore, and this is above 2 crore. So this is your jurisdiction. Okay, guys, this is your jurisdiction. So hello Putul ma'am. What is the exact answer? In the district commission have a jurisdiction to entertain this shall not exceed. And in your syllabus, 2019 Act was there. In your syllabus, 2019 Act was there. So what is the right answer? Because in your syllabus, we have to go through the 2019. So what is the right answer? Yes, Putulma. The district commission have jurisdiction to entertain complaint where the value of the goods and services does not exceed, that is 1 crore rupees according to this diagram. So it is better if you just learn this diagram. Okay. You have to learn this diagram. At least just learn 2019. I'm not saying to learn all 2019, that is important. Now, district commission dispute redressal is established by state government, central government, district collector, or national commission. What is the right answer? District Consumer Dispute Redressal Commission is established by state government, central government, district collector, or national commission. What is the right answer? So class, the District Consumer Dispute Redressal Commission established by, that is state government. So 6th A is the right answer. Okay, now the provision of which of the following will apply relating to the search and seizure under the Consumer Protection Act? It is CRPC, IPC, Consumer Protection Act, or none of the above. Which of the following is the right one? 7th one. CRPC we have already learned in the Prevention of Corruption Act. IPC, which talks about the definition of offense and the punishment. Consumer Protection Act, you know that. None of the above. So which particular following talks about search and seizure? So in India class, this CRPC is a particular act, okay, CRPC, in which the procedure of criminal cases, just like first of all we have to file FIR, then police will investigate, police will prepare the charge sheet. So these procedure is written in CRPC. But I'm not saying that CRPC will apply to the Consumer Protection Act. No. Some some procedure will apply here. So some means the search and seizure, the process in which that is written in the CRPC. So that procedure will apply in the Consumer Protection Act. So for the seventh one, it will be the term. Okay, now when the seller manipulates the price, it is known as what? Unfair trade practices, restricted, manipulated, all of the above. Tell me. Seller manipulate the price. It is known as what? The seller manipulate, it is called restrictive trade practices. Okay, now how many rights does a consumer have under Consumer Protection Act? Tell me. Right to safety, protection, redressal, inform, choose. There's a one more thing. So that's why for the ninth one, six is the right answer. Okay, six is the right answer for this question. Okay, six rights are there. Okay, a complaint relating to which among the following can forward it either by writing. A complaint relating to which of the following can forward either in writing or in electronic mode to any one of the authority, namely district collector or commissioner of regional office or the central authority. Violation of consumer rights, unfair trade practices, false and misleading advertisement, or all of the above. Tell me, class. A complaint relating to which among the following can forward it either in writing, electronic mode to any one of the authority, namely district collector or commissioner of regional office or the central authority. 10th one. The right answer will, for the 10th one, that is D is the right answer.
Hello everyone, very good morning to all of you. Welcome to the Officer Adda 24/7. So in this session we are doing the questions of Module C. So let's start the Module C. As we know that each day, we have just completed the Module A. We have just completed the Module A, then Module B, and right now we are doing the Module C questions, okay? So this is your latest batch which is going on. This is of bilingual and this is your CIB. It's a June 2024. If you want to enroll in this batch, you simply have to apply the coupon code, that is Y391, for the maximum discount up to 81%, okay? This batch is very, very much important. Now, Let's start with the session. Module C, today we will not do the Bankers Book Evidence Act. I have just, it's the Limitation Act that we are going to start. Okay. So what exactly the Limitation Act? See, we know that in India, the population is total 140 crore, right? In India, we have a one Supreme Court, that is the highest court, then the High Court in each state. Total 25 high courts are there, and there are so many district courts. So it is not possible, class, that the court will listen the matter of person at any time. So for any case, what I'm saying, for any case now, there should be a limitation so that the case can be easily filed. Okay. So now in the Limitation Act, first of all, you have to understand that will apply to the any case, that will apply to the any appeal of the case, and that is applied to the application also. Okay, so the limitation will apply in these three particular criteria. Done. Now let's start with the session. Number one question of the screen is that the limitation apply to what? Proceeding before executive authority, proceeding before court, proceeding before quasi-judicial body, or none of the above. These are very, very much important questions, guys. So what will be the right answer for this question? Tell me. What is the right answer for this question? This is very good question. What is the right answer for this question? Yes, class, tell me. The limitation apply to, okay, the limitation will apply to which of the following? And that is important from the examination point of view also, class. This is important for the examination point of view also. Yes, anyone? For this question, as we know that no executive authority, no quasi-judicial body. Quasi-judicial body, it is just like a tribunal. Okay, it is just like a tribunal, but before the court. So that's why for the first one, B is the right answer. Okay, B will be the right answer for this question. Next, Section 3 of Limitation Act does not apply to suit, application, appeal, execution proceeding. Tell me, class. What is the right answer? This is very simple question, okay? Apply your common sense and tell me the answer. What is the right answer? So for this question class, we know that limitation apply to the suit, application, appeal, but not to the execution proceeding. So that's why for this question, D is the right answer. Okay, that is very simple. because in the session also we have learned that, in the paid class also we have learned that limitation will apply to the suit, application and appeal. Okay, if I give you the example of suit, suppose if Nikita ma'am have to file the case to the district commission, the limitation is 2 years. In application, suppose any application, bail application, writ application, there is certain limitation. Appeal also, district commission to the state commission, that is your 45 days. So this is the right answer. Next, where the period of limitation for filing a suit, appeal application expire on the day when the court is closed, such suit, appeal application may be instituted with the court on the day when the court reopened, on the last day before it's reopened, either A and B or neither A and B. What will be the right answer? Tell me, class. What will be the right answer for this question? What will be the right answer for this question? And this is also the previous year question. If I say you, this is the previous year question, this one, okay? And then this one also, the previous year question. Okay, so these two questions are important. What is the right answer for this question, class? Tell me. So for this question, the right answer is when the court will reopen. Okay, when the court will reopen, they have to file the case. A is the right answer. Now, limitation for filing appeal commence means to start from the date of judgment, the date of signing the decree, the date on which application for getting copy was made, the date of getting certified copy of judgment. So what is the right answer? Question again, I'm saying the limitation for filing appeal commence from, start from what? What is the right answer? The right answer is the limitation for filing the appeal commence from the date of judgment. This is the right answer. Okay, class, this is the right answer, the date of judgment. Is that okay? This is the right answer. Now, the fresh period of limitation start in the case of acknowledgement. When the acknowledgement was signed, it was written, both A, B or none of the above. What is the right answer? What is the right answer? The fresh period of limitation start from the acknowledgement. In the paid class, we have also read this point. In the paid class also, we have read this point that in the case of acknowledgement and when the payment was made. So the fresh period of limitation was start. So for this question class, the fresh period of limitation will start basically when the acknowledgement was signed. So 25th, A will be the right answer. Okay, A will be the right answer. Next, acknowledgement was signed personally by agent duly authorized, both A and B, or none of the above. What is the right answer? Yes, class. So what is the right answer for this question? Acknowledgement was signed by acknowledgement was signed by. So for this question, the right answer is both A and B is the right answer. Personally and by agent also. Okay? Now, the period of limitation under this means what? That the limitation is computed in accordance with the provision of limitation. The period of limitation prescribe any suit appeal application by the schedule to the limitation, both A and B or none of the above. What is the right answer? Yes, class. What will be the right answer for this question? And do not forget to like and subscribe the channel of Officer Adda. Okay. So in this question class, the period of limitation means prescribed for any suit, appeal, application by the schedule to the limitation. This is the right answer. Okay. Next. Suit under limitation does not include appeal application, includes appeal application, writ, or none of them. Writ is a kind of order. Writ is a kind of order. Then, so suit under the limitation act is basically does not include the appeal and application. So 40A is the right answer. Okay, because suit is different, appeal is different, application is different. Bar of limitation applied to suit, appeal, application, all of them. Tell me. Bar of limitation. So with this question, the bar of limitation applied to the all three. D is the right answer. Okay. A party who pray for condolation of delay under Section 5 of Limitation Act has to establish that He was vigilant, no negligence on his part, no lack of bona fide on his part, all of the above. A party who pray for condolation of delay. He was to establish that he was vigilant, no negligence on his part, no lack of bona fide on his part, or all of the above. The right answer is he was vigilant. Vigilant means he have to aware with his right, no negligence, no lack of bona fide. Bona fide, that's a good faith. So that's why the right answer is D. Now, where the prescribed period of any suit appeal application expire a day when the court is closed, the suit appeal application may be instituted preferred when the court reopened, on the day before the court is closed, within 10 days after the court reopened, or within the reasonable time. What is the right answer? The right answer is when the court will be reopened. 53. This is the right answer. A very good afternoon to all of you. Welcome to the Officer Adda channel of Adda 24/7. So in this session we are doing the questions of module C. So module C, that is very much important for the examination point of view, because in module C there are total 10 acts. That is very important for the examination point of view, as we know that in the A, B and D module not so much acts are there, but in module C there are total 10 acts, and all 10 acts are very important, in which your SURFACE, DRT, consumer protection, IBC and your integrated ombudsman, these are the important act that is important for the examination point of view. Now let's understand the session. First of all, today is the 31st of January, last day of the sale. So if you have not taken the resolution batch, that is the latest batch, so you can use the coupon code Y391P for the maximum discount up to 80%. Sorry, Y391. What is this? This is Y391. This is a coupon code. In this batch, the live classes are there of all the compulsory subject. You will get the recorded session, okay? Then there are so many mock papers are there of each compulsory subject. Ebooks are there. So I think these materials are sufficient to crack your exam. So do not forget to enroll in this batch. Now class, today we are going to study the Recovery of Debt and Bankruptcy Act. So what exactly this act means? So this act is basically recovery of the debts. We know that the borrower have taken money from the bank and financial institution, right? Bank have given money, suppose, to the borrower. Now the borrower is not able to pay the money. So in this case, what will happen? We know that the bank have an option to go to the court, but we know that in the court do not treat the bank and financial institution as a special one. because in front of the court all are equal. So in this case, what will happen? According to this act, there is a one tribunal. There is a one tribunal which will solve the dispute, and that tribunal is basically DRT. DRT, that is a debt recovery tribunal. So that tribunal will solve the dispute, and tribunal is basically, if I say you, tribunal is basically, okay, a quasi judicial body. What is this? It's a quasi judicial body. So it is not just like court, because in the court we have to follow so much procedure, but tribunal is basically that they can make their own rules and procedure. So that's why this is very important. Okay, and suppose if you are not satisfied with DRT, so we have an option to go to the DRAT. DRAT. Okay, DRAT is the appellate body. So that's all for today's class. Okay, now let's start with the question. Where the appellant is a bank or financial institution, a memorandum of appeal may be preferred by one and more legal practitioner authorized by such bank or financial institution, any CA, CS, CMA in practice and authorize any other officer of such bank and financial institution act as a presiding officer. Both A and C are correct. What is the right answer? Yes, class. What is the right answer for this question? So basically, one and more legal practitioner authorized by such bank, financial institution, and the C is any of the officer of such bank, institution to act as a presiding. D is the right answer for this question. Okay, D will be the right answer for this question. Then next, what are the power and functions of registrar in this act? Tell me, what is the power and function of registrar? Tell me, class, the seal of the tribunal shall not be affixed to the any certified copy issued by the tribunal. Okay. The official seal shall be kept in the custody of registrar. The registrar held shall custody of the record of the tribunal. What is the right answer? What are the power and functions of registrar? The seal of the tribunal shall not be affixed to any certified copy issued by tribunal. The official seal shall be kept in the custody of registrar. The registrar shall have the custody of record of the tribunal, and all of the above is the right answer. Tell me, class. The right answer is all of the above is the right answer. The act which provide for establishment of tribunal for the expeditious adjudication and the recovery of debt due to bank and financial institution, insolvency resolution and the bankruptcy of individual and the partnership firm for the matter connected therewith and incidental thereto is called what? The Recovery of Debt and Bankruptcy Act, the Debt due to Bank and its Recovery Act, the Recovery of Debt due to Bank and Financial Institution Act, or the Recovery of Bank Dues Act 1993. What is the right answer? What is the right answer for this question? You know, class, when this act was made, this was the name of the act. This was the name of the act. But after that, the act name changed, and right now we have the Recovery of Debt and Bankruptcy Act. So this is the old name and this is the latest name of this one. Okay, now, where appeal is preferred by person referred in section 21 of this act, such appeal shall not be entertained by appellant tribunal unless such person has deposited with the appellant tribunal of the amount of debt so due him as determined by tribunal. This is DRT and DRAT. Okay, this is DRT, this is DRAT. Suppose appellant tribunal, suppose any person want to appeal in DRAT, so he have to deposit some amount. So what is the particular amount? 50%, 40, 30%, 20%. And you have to remember, within 30 days, he have to go to the DRAT within 30 days. Okay, within 30 days, he have to go. So what will be the right answer for this question? What is the right answer? The right answer is 50% is the right answer. Okay, next. Where the appellant is other than the bank and financial institution, he may prefer appeal to what? He may prefer an appeal by his agent, in any person, by duly authorized legal practitioner, or all of the above. What is the right answer? So for this one, the right answer is, that is all of the above is the right answer. Okay, D is the right answer. The proceeding of appellant tribunal shall be conducted in English, Hindi, any regional language, or Hindi or English. What is the right answer? What is the right answer? Tell me, class, what is the right answer? So for this question, the right answer is D. English or Hindi, this is the right answer. The Recovery of Debt and Bankruptcy Act extend to whole of India except Jammu Kashmir, whole of India including Jammu Kashmir, or the state of Jammu Kashmir. What is the right answer? The recovery of debt extend to that is whole of India including Jammu Kashmir. Okay. RDB Act shall not apply to where? Where the amount debt due to the bank and financial institution is less than 20 lakh, more than 5 lakh, less than 5 lakh, more than 10 lakh. What is the right answer? Shall not apply. Because we know that if we talk about this act, amount should be 20 lakh or more. Only in that case DRT apply. So I have given you the hint. I have given you the hint class. What is the right answer? What is the right answer? Tell me, class. It shall not apply. This is the right answer. So it shall not apply this one. In all the cases, it will not apply, but 20 lakh is near the amount of the right answer. So that's why this will be the right answer. The chairperson of appellant tribunal, C class. We know that in DRT, the head is called presiding officer, right? And in DRET, the head is called chairperson, right? Now, the chairperson of appellant tribunal, the presiding officer of tribunal, recovery officer, or whatever, it will be called as dash under the section 21 of the IPC. And what is IPC? IPC is basically an act which defined the offense and its definition. That's it. This is called IPC. So, the chairperson, presiding officer, recovery officer, other officer, employees of this one, it will be called as what? Public servant, government servant, private servant, or none of the above. The right answer will be, it will be called as a public servant. Okay? Now, how the recovery officer shall proceed to recover amount of debt specified in this one. Okay, it means what are the mode to recover the debt. The first thing is taking possession of property over which security interest is created or any other property of defendant and appointing receiver for such property and to sell the same. Attachment and sale of movable or immovable property of the defendant. Arrest of the defendant and his detention in person. Appointing a receiver for management of the movable or immovable property. And D is one and more of the above option. What is the right answer? What is the right answer? The right answer will be taking possession of property, attachment and sale of movable immovable property, arrest, and this one. The right answer is D is the right answer. Okay. Who shall make rules to lay down the uniform procedure consistent with the provision of this Act for conducting the proceeding before tribunal and appellate tribunal? It is central government, state government, Supreme Court, and High Court. So the right answer is central government. And always remember, the central government in this act will appoint the presiding officer, recovery officer, or whatever. And nobody can ask question regarding the appointment of this officer. And whatever the act that they are doing, we cannot put any act in the front of the court. So that's all for today's class. Okay, this is one more question. The tribunal, appellate tribunal shall not be bound by the procedure. It means the tribunal and appellate tribunal, they can make their own rules and procedure. So they are not bound to follow the code of civil procedure, because we know that there are only two types of case, civil and criminal, right? So all these things come in the civil one. B is the right answer. Hello everyone, very good morning to all of you. Welcome to the Officer Adda 24/7, the special session of the BRBL subject in the English medium language. So those students who just want to crack this exam in a single and a first attempt, do not forget to enroll in the batch which is already going on, in which one subject is going on. So if you want to enroll in this batch, you simply use the code Y391 for the maximum discount up to 81%. This session is very much important for the examination point of view. Okay, so we are doing module C, right? Let's start with the module C. This is your batch which I was talking about, resolution batch. Okay, this is the resolution batch which is already started. In this batch you will get the live classes plus recorded session, okay, etc. Recorded session and this one, the mock paper, ebooks, etc. for the examination center. Okay, so now let's start with the session. So same act, yesterday also we have done the questions of Recovery of Debt and Bankruptcy Act, and today also we will do the question. Okay, now number one question. Where an appeal is preferred by any person from whom the amount of debt is due to the bank and financial institution or a consortium of bank or financial institution, such appeal shall not be entertained by appellate tribunal unless a person has deposited what percentage of amount that is determined by section 19. So at least you can just learn section 19 also. So tell me class, this is your DRT. Okay, and this is DRAT. So what percentage of amount they will have to pay? Tell me, class. Haji class. What is the right answer here? Tell me. What percentage of amount we have to pay? This is very good question and very important question. Very good and important question. Yes, class. What is the right answer? How much percentage of amount they have to pay? How much? If we talk about the MSME, so in MSME, the amount is your 75% if we want to appeal. Okay. And then if we go through the Consumer Protection Act, same 50% is there. And now in DRAT, what is the particular thing? So class here, at this point, the 50% will be the right answer. Okay, 50%, this is the right answer in which we have to, okay, 50%. So this is the exact particular cost. Is that okay? So at least you have to remember these things. The proceeding of the tribunal shall be conducted Hindi, English, English or Hindi, or any regional language. What is the right answer? The proceeding of the tribunal shall be conducted in Hindi, English, English or Hindi, or any regional language. What is the right answer? In which language the proceeding of the tribunal DRAT will be conducted? So at this point, the proceeding of the tribunal shall be conducted in the English or Hindi. This will be the right answer for this question. C will be the right answer. Okay? Next. The application made to tribunal shall be subject to the provision of IPC, CRPC, Criminal Procedure Code, POCSO. First of all, we have to understand that what exactly this means. IPC, this is a law book in which the definition is given and its punishment is given. Definition and the punishment is given in IPC. Okay, the definition of the offense and the punishment. See, this what is this? The short form is CRPC. CRPC, that is a criminal procedure code. So whatever the crime that has happened in the society, so what procedure the court have to follow, that is given in CRPC. Okay, criminal case just like murder, rape, theft, etc. This is called CPC. So CPC, both are all are national law that is made by the parliament. CPC is that law in which in the civil matter, okay, in the civil matter, what procedure they have to follow. That is called CPC. Is that okay? And then POCSO Act, that is a prevention of children from sexual offense act. Whatever the sexual offense that is happening to the children, so for the protection, this act is there. So these are the 4 acts that is given in this. Okay. So the application of tribunal subject to the provision of that is CPC, because in the banking matter also the matter is of civil case, not criminal case. So that's why for the third one, C will be the right answer. Okay, what is the right answer? C will be the right answer. Done? That's now. How the interim or final order passed by tribunal or appellate tribunal shall be served on the party. Any interim or final order passed by tribunal or appellate tribunal shall be transmitted by electronic mail to the registered address of the parties to the proceeding shall be deemed to be served on such party. Any interim or final order passed by tribunal or appellate tribunal shall be displayed on the website on such tribunal or appellate tribunal shall be deemed to be the public notice. The order passed by tribunal or appellate tribunal shall be handed to the concerned part in the physical mode duly certified. Both A and B is correct. So which of the following is the correct one? If I talk about the interim, so interim means that is compensation. What is interim? Compensation. And the final order, that is the last order. That is called final order. So what is the right answer? What is the right answer for this question? Aji class, what is the right answer? For this question, the right answer is, that is D is the right answer. Okay, now, who is the adjudicating authority for exercising the power under insolvency and bankruptcy? Who is the adjudicating authority? High Court, District Court, DRAT, DRT. Who is the adjudicating authority for exercising the power under insolvency and bankruptcy? High Court, District Court, Appellate Tribunal, or DRT? The right answer is fifth one. The right answer is, that is adjudicating tribunal. This is the right answer. Okay, tribunal is the right answer. Now, debt include any liability toward debt security which remains unpaid in the full and the part after the notice of dash serve upon the borrower by the debenture trustee or any other authority in whose favor security interest is created for the benefit of this. It is 180 days, 90 days, 60 days, or 30 days. What is the right answer? Debt include any liability toward debt security which remains unpaid in the full or part after the notice of dash serve upon the borrower. So the notice of what? Notice of 60 days will be given to the borrower. So this is the right answer. Okay, 60 days. The presiding officer of tribunal shall hold office for a term from the date on which he entered upon office and shall be eligible for reappointment. So what is the term of presiding officer? The term of presiding officer is, I think that is very easy one. The term will be class, that is 5 years. B is the right answer. Next, No person shall hold office as presiding officer of tribunal after he has attained the age of 65 year, 62 year, 60 year, or 58 year. This is very important question. These are very, very much important. So for this one, the right answer is 65. A is the right answer. Okay. It's a DRAT shall consist of one person only. Okay. That is a chairperson appointed by notification by state government, central government, high court or supreme court. It means who appoint the chairperson. Who appoint the chairperson. So who appoint the chairperson, that is central. Okay, this is right answer. Okay. The chairperson of appellate tribunal shall hold office for a term from the date on which he entered upon his office, shall be eligible for three appointment also. So what is the right answer? 7 year, 5 year, 3 year, or 1 year? What is the right answer? The chairperson of appellate tribunal shall hold office for a term from the date on which he entered. The right answer is 5. Okay, next. No person shall hold office as a chairman after he has attained the age of, what is the right answer? 75, 70, 65, 69. The terms tenured, that is very important. What is the right answer? The right answer will be, that is 70 years. So please remember, this is presiding officer, this is chairperson. Presiding officer 5 and 65, and that one 5 and 70. Okay? Now, what is property? Intangible asset. Intangible, that we cannot see and we cannot touch. Movable and immovable. Any debt, any right to receive payment of money, whether secured or unsecured, or all of the above. So what is property? So here, property is everything. D is the right answer. Okay. A person shall not be qualified for appointed as a chairperson of appellate tribunal. It means now you have to remember the qualification of chairperson. Has been a member of Indian Legal Service and can hold a post in grade 1 of that service. Presiding officer at least 3 years and qualified as a judge of high court. Or all the options are correct. So what will be the qualification of the chairperson? That is very much important. The right answer will be all options are correct. Okay, next. For the purpose of exercise of general power of superintendence and control over tribunal, The chairperson may direct the tribunal to furnish information relating to the pending cases, the number of cases disposed of, and the number of new cases filed, and such other information as may be necessary. Convene meeting of presiding officer of tribunal periodically to review their performance. Surfacing, DRT or all of the above. For the purpose of exercise of general power of superintendence and control over tribunal, the chairperson may direct the tribunal to furnish information relating to the pending cases, number of cases disposed of, and the number of new cases filed. So under which act that have a power? That is a DRT. Okay? Now, in how many days the defendant shall be present the written statement of his defense, including claim of set-off and the counter-claim of any. It means C class. Plaintiff is a person who filed the case, right? And defendant to whom we are filing the case. Done. So plaintiff, whenever the plaintiff files the case, okay, whenever the plaintiff files the case, so the opposite party have to give the reply. So that reply, within how many days the defendant have to give the reply? This is the question. Very good question. This is called written statement of the defense. That is called written statement. So the written statement always within the 30 days. So class, I hope so you people enjoy the questions because the questions are very much important. So this is your batch. Okay. So do not forget to enroll in the batch. The coupon is 5391 for the class. You can also take the particular elective batch for this the video course batches. You can enroll it here, and this is the CAIIB Mahapacks. TV is going on. TV is going on double validity. Okay, so do not forget to enroll in the Mahapacks. In the Mahapacks, you can see for admission you can call here. Live classes for more than 500 hours. Structured course content for this. Case studies batches are there. Highly experienced faculties. Detailed subject expertise. Special exam focused revision batches. Recorded videos. Full walk length. Ebooks. All the news labels. So everything is included. Please apply the coupon code. This one for the maximum discount. Okay? That's it. You can also download the Adda 24/7 app in which you will get the quizzes of all the subject. Okay, so if you want to solve the quiz, you can please download the Adda app through the. So that's all for today's class. Have a nice day.